When can educators use materials created by someone else? What happens when a teacher creates a learning activity packet for her class that includes 11 pages copied straight from a copyrighted work? Jamie, what do you know about cake decorating?
Cake decorating? Very little.
Yeah,
Just
me too.
what I watch on those baking shows on Netflix.
Yeah.
I can eat cake. I am a big fan of eating cake.
Yeah.
So that's about where my talent.
Okay, so I would say you've got
stops.
relevant experience.
So today we're going back to the 70s and the 80s because this took place over a very long period of time for our first case, folks, about copyrights in education. Copyrights and cakes. Cakes and Copyrights. It's the title of the episode. Here we have a teacher who copied some material from a copyrighted book called Cake Decorating Made Easy.
It was written for you, Jamie.
For me, yeah. They need to make it really easy. So she copied about 11 pages of this book for use in her home economics class. So we're going to talk about that case today. So welcome to Chalk and Gavel, everybody, where we explore how the law shapes education, one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now, Jamie and I are both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, welcome back, everybody. Just a few quick announcements. Please rate and review Chalk and Gavel. If you are checking us out on YouTube, please give this video a thumbs up. That would go a long way to help us spread the word. We also have a teaching guide available on our website, chalkandgavel.com, and we would love it if you would consider supporting the show on Patreon for just $2 a month. Go to patreon.com/chalkandgavel. Help us keep bringing you all this fun school law stuff. So speaking of fun school law stuff, what's our bell ringer today, Chris?
Yeah, this one is a ton of fun because we finally have the executive order regarding the Department of Education. So this is the Trump executive order that was signed on March 20th. We are recording this on March 28th, so it's pretty hot off the presses, but this is the order that ostensibly seeks to close the Department of Education.
Great.
Yeah. So I've got the order up in front of me. And part of me is like kind of just, I feel relieved that we have the order now, right? Like it's got
we know
text.
what we've been sort of hinting at.
Right.
what
Yeah. We
has
knew
been
it was
sort of
coming,
hinted.
right?
Yeah.
Like
Yeah.
it was coming down the pipe. It had been rumored. There have been, massive layoffs and things like that. So like now we at least have maybe not the order. Like this isn't going to be the final step, as we'll talk about here in a second, but like it's good to know, right? Because if we know, we can actually respond to something concrete rather than just speculating, right? So the order is titled Improving Education Outcomes by Empowering Parents, States, and Communities.
It's interesting that parents is listed first there.
Especially because the justification is to move education decision-making back to the states where it belongs,
Yeah.
right? Yeah, so that is an interesting ordering. And the order itself, or not the order, the
executive order, not the order of the...
Right. Yeah.
I'm with you.
Sorry. The executive order itself, like most of it is just preamble. Like it just kind of explains the justification for why the Trump administration wants to close the Department of Education, remove educational authority, move it back to the states, just kind of gives some of the historical background. But like what I would call the legally operant provision here, I don't think it does anything. And that's my take on this whole order is in many ways, it just kind of like puts into writing what the Trump administration had already been doing.
Yeah.
So the text of the order that like actually tells the Secretary of Education what to do says the Secretary of Education shall, and this is a really important phrase, to the maximum extent appropriate and permitted by law, take all necessary steps to facilitate the closure of the Department of Education and return authority over education to the state and local communities. That's a really interesting phrase. To the maximum extent appropriate and permitted by law.
Right, because if you've been following this, folks, you know that it would take an act of Congress to actually officially eliminate the Department of Education.
Right, because Congress created it, and Congress also told the department what to do, right? So, like, administrating the IDEA, administrating Title I, overseeing the Every Student Succeeds Act, like, all of those things are things that Congress told specifically the Department of Education to do. So that phrase, like, to the maximum extent appropriate and permitted by law, recognizes that Trump and the Trump administration don't have the authority to shutter the department or even to have it stop doing the things that it does. You know, some of the stuff it does is more discretionary and they have control over that, sure. But like the core
functions of the department are established
are statutorily mandated. Yeah, exactly.
Yeah.
Right. And so like this kind of just, I guess, puts into writing what we know they were already doing, right? Because we saw all the layoffs, all the reductions in force.
Which reinforces that, you know, we don't want to give the impression that what's happening is negligible or inconsequential or whatever,
for sure.
Right? Like there are significant consequences that we've already experienced and that, you know, many are living on a sort of daily basis, those who are no longer employed by the Department of Education, things like that.
Yeah, their staff is about half of what it started at.
Right. There's a lot of uncertainty around funding, around access to data. There's, and a lot of that has already been eliminated. So while the administration might not be able to go as far as they want to go because of the limits placed on that degree of authority, they can still do a significant amount of damage, for lack of a better word, to the existing structure.
There can still be a lot of disruption to the work of the department, right?
Yeah.
And that's one of
to the work of a lot of people outside of the department.
That's right, because
we both have lots of colleagues who
rely on federal data.
Who rely on federal
and grants and all that stuff. And two more things about the order that I want to kind of highlight. Jimmy, you kind of alluded to this, like the order itself, you know, the continuation of the phrase that I started to read says that the secretary will work to close the department while ensuring the effective and uninterrupted delivery of services, programs, and benefits on which Americans rely. Because that's a huge question. It's like, what's going to happen to my kid's IEP? Right. Like, you know, that's a federal law. It's overseen by the Department of Education. So, like, there's really profound questions here. And, you know, I think this is part of the efforts to make this change less disruptive and perhaps more palatable is like continue to do the work. It's just not going to be done by the department.
Right.
And when we're making that transition, we want to make sure that the, you know, core functions still get accomplished.
Now, and the big question there is like, A, who's going to take over those responsibilities? And B, do they have the necessary expertise and tools and resources wherever this ends up going to actually carry out those functions properly?
Yeah,
we don't know.
Lot of questions. And, you know, we're not going to have answers until Congress acts, really.
Right.
But the last thing I want to point out about this executive order, every executive order has a section on general provisions that basically just kind of like tell you what the order does and doesn't do. And it's all boilerplate because it's pretty much the same from order to order. But it's really ironic in this case because one of the general provisions, Section 3A, says, quote, nothing in this order shall be construed to impair or otherwise affect the authority granted by law to an executive department or agency. So it's ironic that the executive order ostensibly closing the Department of Education doesn't affect the authority granted by law to the Department of Education. I just found that ironic.
Yeah, that is ironic.
But it highlights the limited scope of this order, right? Like, Jamie, to your point, not to downplay the practical impact and what can actually like happen, but like this order, it
illustrates that the administration can't go as far as they clearly want to go.
Or as people have been reporting, they've already gone, right? Like that's something that I think gets lost is like, you know, the words on the page here don't align with how kind of a lot of people are popularly understanding what's happening.
Yeah. Everything's going away.
Right. Yeah. And it is very much not.
And it can't. A lot of it
Hmm.
can't with, or at least it can't with the stroke of a pen from the president.
Right.
Like there's
Yeah.
a lot more that has to happen in order for it to actually go away.
Right. And that doesn't mean it won't. It just means that there's going to be more people involved in the decision making process, and it's going to take an act of Congress or something similar.
Right. Right.
Yep. Yep. Yep.
All right. Well, as usual, this has pretty much been, I would say, almost every bell ringer for the last couple of months has been something to do with
The new administration.
the
Yeah.
new administration and what's happening with education. And so I don't see that slowing down anytime soon. So
No,
we'll
but
keep,
we're getting into Supreme Court season, so we'll have to start adding some of those in here too.
that's right. Actually, yeah, by the time this episode comes out, this episode is coming out. Oh, cool. The day this episode comes out is the day that I will be up at the Supreme Court listening to the oral arguments for the Mahmoud versus Taylor case.
Yes. Oh, I'm so
Yeah.
pumped. That's
Yeah,
so exciting
if
that
you
you
are
get to do
listening
that.
to this right now, Jamie is sitting in the Supreme Court. Well, if you're listening to this on the day it comes out, I'll be up in the Supreme Court for the oral arguments in that case. And of course, folks, we will be covering that.
Yeah.
Uh,
Yeah. Be fun to
um,
do an entire episode just unpacking the oral arguments. Because I think
Well.
there's a lot of confusion about like how the Supreme Court makes its decisions and what role
Mhm.
all of that plays. So I think,
Maybe we
it's
should
always
do it.
yeah, it's fun to read the tea leaves too of like
Yeah.
what justices ask what.
Yeah.
Cool. I'm
Yeah.
super pumped. Because you'll be hanging out with Mark Walsh too, right?
Yeah.
Nice.
Mark Walsh is a good
Friend
friend
of the
of
show.
ours and a friend of the show. And he's the Supreme Court one of the law reporters for Ed Week. Great guy. He's been on the show a few times. So I'm going to go up there and hang out with Mark and
Sweet.
go check out those oral arguments. Anyway, you ready to get into today's copyright case?
I am thrilled.
We really wanted to have some good 80s background music for this episode, but that would be a copyright problem. So we have explored the sort of royalty-free public domain 80s music instead, because that's what we're allowed to use, and we don't
Right.
want to infringe on any copyright laws. So let's
Mhm.
talk a little bit today about the copyright laws and how all of this stuff works in education.
Let's do it. Yeah, it would be ironic if we were talking about copyright and we were
And we're infringing on copyright.
infringing on copyright. Yeah.
Yeah. So, whatever you hear music wise in this episode, we promise you we either hold the license for it or it's royalty free public domain kind of stuff. So, today's case starts in the 1970s. It ends in like 1983. So, it starts in around 75, 74, 75, somewhere around there.
As with most of these situations,
Takes a long time.
it takes a long time.
Okay. So at the heart of this case, we've got two teachers. All right. We've got Eloise Toby Marcus. I'm assuming it's Eloise, and Shirley Rowley. Both in different Rowley. It's
I was
not,
going to say, like, how common of a last name is Rowley?
well, it's common enough to have a couple of good education
Law
cases.
cases, right? Yeah.
So the other case was Board versus Rowley, which was a special education case. But this is not that. It's a different Rowley, we think. Are they any relation to one another? We don't know. We didn't look that up.
I looked it up.
You did?
Well, no, I looked up who Amy Rowley's parents were, and I think her mother's name was Nancy. So at the very least, this is not
Not
Amy Rowley's mom.
It's not in the immediate family.
That's all I know.
That's all we know.
Yeah.
All right. So we've got Eloise Toby Marcus and we've got Shirley Rowley, both of whom taught in the San Diego Unified School District. All right. So Eloise was a home ec teacher with the district from 1972 to 1974. Okay. Then she left the district to teach adult education courses between 1975 and 1980. Okay.
Okay.
And to support her adult education courses, she wrote a little booklet titled Cake Decorating Made Easy. And that booklet contained 35 pages of, what do you think?
Probably instructions and information about how to decorate a cake.
That was a great guess.
Hey.
So of those 35 pages, 29 of them were Eloise's original creation. Okay, the remaining 6 pages were material that she incorporated from other authors with their permission and with appropriate credit. Okay,
Okay.
Take note of that. That's a little important. That might come up later.
I was going to say, I feel like copyright and permission might be at the core of this case.
Yeah, well, I mean, there's probably a few cores of this case, and
Mm.
that is definitely one of them, right?
Yeah. Thought you were
So,
going to try to make a layers joke because it was right there with the layers of the
layers
cake.
cake.
Yeah.
Yeah.
I'm disappointed in you, Jamie. We haven't had any cake puns
I'm sorry.
yet this episode.
I will do better, folks. I will do better.
Uh-huh.
So Eloise did her whole deal. She did it by the book. She did the book by the book, right?
Okay.
She registered for the copyright. She, did that through the standard register of copyrights. She then had 125 copies of the book made in the spring of 1975. And in those copies, they all contained the copyright designation, the little C with the circle
Right. Yeah.
around it.
Usually followed by like copyright
Their name or
1975.
publisher or something like that.
Mhm.
So this was all copyright Eloise Marcus.
Okay.
And it was in the table of contents. It was on the first page. It was on the page following the cover title sheet. So it was very clear that this material was copywritten.
Yeah. This sounds pretty official. Like this is official self-publication.
Yeah, exactly. And Eloise used this book as a part of her adult education classes. She sold 119 of those booklets to her students at $2 each, and she
man.
made
Breaking the
$1 per
bank.
book.
Okay.
Yeah.
Um,
It was $1975,
right,
so
yeah.
it was probably, it's like equivalent of a $400 book now. Sorry. Okay.
No, I actually did the math. And if she made $1 a book and sold 119 books, that means she made about $700
In today's money
that she made, not
that she made,
per book.
not per book, right?
Yeah.
Yeah.
No, each book costs the equivalent of like $10 today.
Yeah. So things start to get interesting here. So remember how we said that this involves 2 teachers in the San Diego Unified School District? Well, our other teacher, Shirley Rowley, ends up taking Eloise's cake decorating class, the adult education cake decorating class. She buys a copy of Eloise's book for $2. And there you go.
And she didn't do anything problematic with that copy.
No, not until she goes back to her own food service career class that she's teaching in the San Diego Unified School District. And she was very proud of all of the things that she learned from Eloise's course, because the next year she started teaching an optional section in her course that was devoted specifically to cake decorating.
Oh, cool. So she took what she learned, took it back to her students. Okay. I mean,
She
hey,
took more than what she learned.
Uh-huh.
So, as a part of this optional section on cake decorating, Rowley prepared a 24-page cake decorating learning activity package.
Rolls off the tongue.
It does. She made 15 copies, and she kept them in a file for students who elected to study cake decorating. Okay?
Okay.
Now, of the 24 pages, 11 were copied directly from Eloise's Cake Decorating Made Easy.
Okay.
Okay.
Now.
Here's where we get into the problem.
Uh-huh.
Okay. Those pages included supply lists, icing recipes, how to do color flow and mix colors, how to make and use a decorating bag, and 2 full pages explaining how to make flowers and sugar molds.
There's
Okay?
a lot more to cake decorating than I would have expected.
I know. Well,
The,
but
the
you
people on
should-
Great British Bake Off always make it look so easy when they like put the icing in the bag and like snip
Yeah.
it and squeeze it out.
Well, you should watch the Nailed It show, because then it shows you how all of that stuff plays out in reality. Anyway, Shirley Rowley did not give Eloise Marcus credit for anything in those 11 pages that she took directly from Eloise's book.
Uh-huh.
Okay? Didn't acknowledge, didn't mention Eloise's name, just basically copied those 11 pages, stuck them in there
Right.
into
And
her packet.
she did retype it, right? Like it wasn't photocopies.
No, but it was a verbatim copy.
It was a verbatim, like just typed
It might
up on
as
her-
well have been a photocopy, because it
Right,
was
yeah.
verbatim.
Yeah. Okay.
All right. So everything was fine from 75 to 77. But in 77, some really interesting things happen. First of all,
Star Wars was released.
Star Wars was released.
Hey.
Jamie Cudlitz was born.
Whoa. I didn't realize you were as old as Star Wars.
Dude. And one of the parents of Shirley Rowley's students enrolled in Eloise's cake decorating class.
Ooh, okay.
Okay. Yeah. So things are starting to come full circle here. There's stuff going on in San Diego. So the parent had apparently obtained a copy of Shirley's cake decorating learning activity packet, and she decided, well, wait a second, I've got all this stuff. I don't need to buy the book for this adult education.
Right. I've already got the material.
I've already got this stuff. Interestingly, the parent had it all backwards, and she accused Eloise of plagiarizing Rowley's content, the activity packet.
Oh, so she
Yeah.
assumed that Eloise, teaching the adult class, copied the material that she got, that the parent got from
the kid
the kiddo.
who's in Rowley's class.
Yeah. I bet
Yeah.
that made Eloise very happy.
My guess is she was not too happy about that because what?
Because we have evidence that she was not too happy about that because she filed a lawsuit.
There you go.
Yeah. So Eloise brings a claim for copyright infringement against Shirley and the district. Both Shirley and the district deny infringing on Eloise's copyright. And we're at the trial court level, so we're in federal court because this is all federal copyright law. And both parties file cross motions for summary judgment, and the trial court ends up dismissing the case, concluding that Shirley's use of the booklet was for educational purposes and that constituted a fair use. So there's a lot of words in there we're going to unpack.
We're going to unpack
because
all of that for you because that will help you decide when you may be or may not be in danger of infringing on copyright. Because listen,
Right.
This is something, the reason why we're doing this case is because this is something that comes up so often in schools. Teachers use materials from all over the place to help them impart knowledge to students, right? And so this kind of stuff happens all the time. So
right. And it's something that a lot of people have a lot of questions about because it's not clear cut, right? There are no hard and fast rules here when we're talking about using other people's materials in your teaching.
But there are rules. They're just not hard and fast. They're soft and slow.
Exactly. Yeah. I think that's the alternative, right?
Yeah, I guess.
Yeah. I call them squishy. They're squishy rules.
Yeah. So basically, the school district and Shirley Rowley wanted this thing tossed out because they were basically saying, we think the use of this material is fair use. And the court initially said, yeah, probably. So let's toss it all out.
Right. Exactly. But that's not the end of the story because
she appealed.
She appeals to the Ninth Circuit Court of Appeals. So the primary question on appeal is whether or not Shirley Rowley's use of the booklet constitutes a fair use of Eloise's copyrighted work.
Okay.
So let's take a little bit of step back and just kind of talk about copyright law.
Yeah.
I think that's probably a good idea.
Yep.
So copyright is essentially just protection of intellectual property.
Yep.
The goal of copyright, and the reason I talk about the goal is because it's going to come into play when we're talking about like what constitutes fair use, but the goal of copyright is to essentially just kind of promote the progress of, quote, science and the useful arts. We want people to own the things they create and to be able to benefit from those things. So
and
like,
we don't want people to steal the benefits of something that was created by somebody else.
Right.
Right.
But on the other side, we also want to recognize society's interest in the transmission of
progression.
information and culture and all of those things. So like it's a balance between the individual rights and kind of collective rights or interests. So like that's why copyrights typically expire after a certain amount of time. Like we want people who make stuff to be able to benefit because we want to motivate them to make stuff. But we also want society to benefit from the stuff that people make, right? So it's a balancing act. So that's just kind of like, I guess, the goals of copyright law. Right. So the way copyright law actually works is it protects works in, quote, a tangible form, and it protects them from the moment they are created. So the moment you put something into a tangible form, And that could even just be like typing it up on a computer. That's when copyright protection attaches. So it doesn't have to be published. If I today wrote a song and put it in wrote it down on a piece of paper and put it in my file cabinet.
Yeah.
And 20 years from now, Taylor Swift goes and finds it and records it and makes $1 billion. Like, my copyright attached as soon as I wrote it down. So like technically I would have copyright for that
I
song.
mean, I
And
have
it's not
other,
going to happen
I
for a
well,
lot of reasons.
I mean, I have other questions like what's she doing in your filing cabinet 25 years from
What am I doing writing a song is probably a better question.
How did Taylor Swift get into your house?
Well, this is my office, but maybe she's a professor at the University of Florida now. Who knows? Right. And so like what copyright does is it essentially gives the person who holds the copyright exclusive rights to republish the work, to reproduce the work, to create derivatives of the work. Like, it basically says, hey, other people don't steal this.
Yeah.
Right.
And the person who wrote it, you can do whatever you want to with it.
Right. Yeah. And other people,
You can.
hands off, at least for, I think right now it's 70 years after the life of the individual.
Yeah, something like that. But there's carve outs to this, right, Chris?
There's some really important exceptions that are relevant to education. Because, if copyright didn't have these carve outs, then no one could do anything with stuff that other people already published.
Right.
So 2 really important carve outs for education. The first is not relevant to our case today, but it protects the performance and display of copyrighted works in face-to-face and online classes. So this essentially means that, like, if you show a movie in your class, you're not infringing on anyone's copyright because you're showing it in class for educational purposes. And, assuming that you appropriately obtain the copy that you're showing, you're fine. So, like, this would cover showing movies or like performing plays,
playing a song.
music, playing a song, whatever in class.
Yeah.
So none of that is a problem.
Yeah.
But the more crucial exception, and the one that is at the heart of today's case, is fair use. So fair use allows others to use copyrighted materials in a reasonable manner without infringing on that copyright. So if it's a fair use, it's not infringing the copyright. And
so how do we determine if something is fair use?
You just ask if it's reasonable or not.
Oh, well, then there you go. Case
As with
closed.
everything.
Have a good day, everybody.
Yep. Right. I know. The law loves the word reasonable.
I know, right?
Right. And it means nothing. That's how it feels sometimes. Sometimes it feels like
they
it
love
means
the
nothing.
word reasonable, and that in it of itself is quite unreasonable.
I would agree. It is unreasonable to find everything in the law. But that's also what I tell my students. Like, hey, if you act reasonably, 90% of the time, you're going to be fine.
You're fine.
Yeah.
What does that mean? Yeah, you figure it out.
Right, exactly. Yeah, it's like, well, I don't know. But anyway, fair use in education, like one of the recognized examples of fair use that goes all the way back to Congress's deliberations around the Copyright Act is teaching.
Yeah.
One of the examples, it's an illustrative example of fair use, is using copyrighted materials in teaching for nonprofit teaching activities, right? And so basically, like, you're not selling them. You're not trying to make money off of this. You are just giving it to your students as part of the learning activities. But just because you're using it for these nonprofit learning activities doesn't necessarily mean that it's automatically fair use.
So that's part of, like, there's a number of things we have to look at, a number of questions we have to answer to determine whether or not something is fair use. And so that first one is whether or not this is being used in sort of like a non-profit, like we're not trying to make money off of this thing.
Right. Yeah. And so that actually comes in a couple places. But yeah, so Jamie, you alluded to it. There are 4 factors that we have to balance to determine whether or not something is fair use. So not only is this not black and white, it's also not a list of check boxes, right? Like, it is a factor test, which means we have to balance all of these different interests. And to make it even more fun, we took 4 things that you have to balance against all the other things. So like this is a very complicated area of law. That being said, most people do pretty okay most of the time. So take it with a grain of salt. But here are the 4 factors. We have to look at, number 1, the purpose of the use. So the purpose that the alleged infringer, what are they using the work for? Second, we look at the nature of the copyrighted work. So is it creative? Like, how close is it to the purpose of the Copyright Act and all of these things? We have to look at 3, the amount and substantiality of the portion used. So if you use a lot of the work,
Right.
and if you use kind of like what's called the heart or the core of the work, then that might be a problem. And then last, we look at the effect of the use on the market for the original work. So if you basically make
If
it
you
less
take
likely,
away,
exactly.
yeah,
Yeah,
the
if you
ability
take
for
away
the
market
original,
share,
yeah.
so like, that's why, Weird Al is probably never going to get dinged for copyright infringement, right? Because like
Fair use protects parodies.
fair use protects parodies. That's one of the purposes. Like that's a purpose that is protected.
Right.
And also like if I listen to a Weird Al song, it's going to make me more likely to buy the original or listen to the original because like
Right.
they're totally different.
And he didn't do it to replace the
Exactly.
original or to take away from the original. Now, I interestingly, I do know, because I'm a big Weird Al fan as a child of the '80s.
As we learned.
I was under the impression that he almost always seeks the permission of the original artist,
Right.
even though he might not need to.
Right. Which also means he's got permission. So if he's got permission, then doesn't have to worry about copyright because
Right. And that's a big thing, right?
Mhm.
Like we see this come up in this case a lot and in other cases, copyright cases. If you make an attempt to get permission, that's something that the courts are going to look at.
Right. Yeah. And that actually comes up in this case, right?
It does.
Yeah. So those are the 4 factors. We need to
Okay.
look at the purpose, the nature, the amount, and the effect. So let's apply that to Eloise and Shirley.
Okay.
The Ninth Circuit is looking at whether or not Shirley's learning activity packet was a fair use of Eloise's cake decorating made easy booklet.
Right.
And they apply these 4 factors. So first up, purpose. What was Shirley's purpose for using the booklet?
It was educational. Right?
Yeah, right. It was educational. It was very much for nonprofit educational purposes.
Mm-hmm.
So that weighs in favor of finding for fair use.
Yeah.
But there's more.
Of course.
There's always more, right? So the court also looks at a couple other things. They ask whether or not the allegedly infringing use has the same purpose as the original work.
Oh.
And so because the original work was also written for educational purposes, using it for educational purposes, like that becomes
that
a problem
kind of
because
weighs
it's not
against fair use.
it weighs against it because it's not transformative. It's
Right.
not like changing it in any substantial way. Like
Right.
you're using it for the intended purpose, which, the question is like, then why didn't you just get the other one?
Yeah, exactly.
Right. So that weighs against finding for fair use.
Mhm.
The next, and this is, Jamie, what you were just alluding to, the court looks at Shirley's behavior and whether or not she engaged in bad faith behavior or denied or refused to give the original author credit. And here, like, Shirley knew who wrote the book. She
Mhm.
could have probably very easily contacted her to get permission or to get copies of the book, and she didn't. And she also, in nowhere in her packet, gave Eloise credit for the work, saying like, hey, this is derived from, or hey, this is copied from Eloise. And so both of those also weigh against finding for fair use. So on this first factor, the court kind of says like, well, it could go both ways. So it's a toss up.
So what about the second thing, the nature of the copyrighted work?
Yeah. So the nature of the copyrighted work basically just looks at how close to the core purposes of the Copyright Act the original work is. So if it's a highly creative work, that's what we want to
To
protect.
protect the most, right?
Yeah, that's the most strongly protected. But if it's like nonfiction or just kind of a recitation of facts, or if it's a description of stuff that's kind of already in the public domain, that sort of stuff is less strongly protected. So creative works, strongly protected. Stuff that everyone already knows, less protected.
Right.
We look at that and like, this is also kind of a wash because a lot of this stuff that Eloise put in her book is like, that's common practice for people who decorate cakes.
Right.
But the court also says that, just because some facts and information was widely known, a lot of it also derived from Eloise's experiences and expertise. And so because of that, like there are creative elements here. Like she had to not only kind of structure the book and decide on the table of contents and how to present the information, but there are things in here that are not common knowledge, which is what Shirley Raleigh was trying to argue. She's saying like, all this is common knowledge, so it's in the public domain anyway, so it wasn't really a creative work, so therefore it's not really protected. The court says, this
It's
one kind of also is unhelpful because it could kind of go both ways,
Right.
even though we're kind of leaning towards recognizing that some of this at least represents strong creative expression.
Yeah, like she had to synthesize and decide, make decisions about what is important to include and what isn't important to include. And yeah, so there's a creative element to this.
Right.
Yeah.
Yeah. So that one is also kind of a wash.
Okay.
So we're 0-0 so far
yeah.
on
Okay.
these
So
factors.
the third one, which has to do with like how much of the material was used, right?
How much and how important was the
Important
portion
was-
used?
Right.
Right? Because like even if you take a very small portion, if it's like the
core
crux of
idea.
the entire
Yeah.
thing, then
Yeah.
that's a problem.
Yeah.
This is kind of what trips up a lot of educators, I think, because this is what everyone wants answers for, right?
Right.
Like they want answers for, okay, yeah, but how much
much?
of a book can I copy?
Yeah. And
How
it's
much
not,
of a book can I give?
yeah, it's not that simple, right?
It
like,
isn't. No.
Yeah.
We've got to look at like, yeah, again, how much did you copy and how important is the piece that you copied?
Right.
And this is tricky because we want hard and fast rules and there aren't any. When Congress was passing the Copyright Act, it offered some congressional guidelines that it says set minimum standards for what constitutes fair use. And it did that to kind of like provide guidance, right? To like help us figure out where the lines are.
Mm-hmm.
I don't necessarily know how helpful these are, but the guidelines kind of laid out a number of conditions that need to be met for classroom use to meet what Congress said or like the minimum for fair use. So like I take that to mean that like courts can't go below this, but like stuff that is more substantial uses than this aren't automatically not fair use, right? So the criteria that Congress gave us, first, the copied portion has to be less than 2,500 words or 10% of the work, whichever is less. That's not a lot, right?
No.
That probably is less than a chapter of a book.
Yeah.
I mean, 2,500 words,
It's not a lot.
that's barely 10 pages.
Yeah.
Second, the use has to be spontaneous, meaning that you didn't have time to get permission or obtain sufficient copies.
Okay.
Basically, like you have to justify why you had to engage in a fair
Do this
use.
so quickly that you didn't have time to
Exactly.
reach out to somebody. Yeah.
Yep. Third, the copies can only be used for one class one time. That goes back to that, like you didn't have time to get
Mhm.
permission or to get
Mhm.
more copies, right? Like, because if you use a photocopy version for multiple years in a row,
Yeah.
like
Then
one,
you've had time.
you've had time. And also that's more kiddos who have seen, and it's more replacement of the copyrighted work, right?
Right.
And then fourth, you need to include a notice of copyright saying like, hey, yeah,
This isn't mine.
I
yeah.
took this from this source.
Yeah.
Right.
Exactly.
Now, importantly, none of that is binding. So take it all with a huge grain of salt. Those are minimum standards and they're from Congress. Like courts don't have to follow those. And that's why balancing these fair use elements is so important. So like there are no hard and fast rules. Like,
yeah. So the courts
you
will
can-
look at that. Well, they'll look at those guidelines, but those aren't the only things that the courts will consider.
right.
Yeah.
Right. Yeah. And like courts aren't going to say, oh, well, you copied 2,504 words. Therefore, that's not fair use, right?
Yeah.
They're not going to do that.
Yeah.
But like, that's why kind of, there's a lot of rules of thumb around copyright.
Yeah.
And educators just have to be really careful about whether they copy too much
Yeah.
and how that all works. So like, there's some really good checklists and resources online that I found really helpful when I'm thinking about these things. But it's one of those things that educators should definitely be aware of.
Totally. And so this is where things start to put Shirley Rowley on some shaky ground here, right?
Yes.
Because she copied verbatim 11 pages of a 35-page book. That's a
Right.
lot. That's a lot
It
more
is.
than 10%.
And the 11 pages she copied were the heart of Cake
Oh.
Decorating Made Easy.
Oh,
Because like, so there were 35 pages. I think 7 of those were like title page and table of contents and stuff. So we're already down to like 28.
okay.
And then of those 28, I think a handful were from other folks. And then a handful were also like public information from like different organizations. So of the stuff that Shirley copied, it was almost everything that Eloise contributed to the work that was like at the heart of her creative expression.
Okay.
Right. And so according to the court, like the only thing that Shirley didn't copy from Eloise's portions of the booklet that she wrote were hints on how to ice a cake and an explanation of how to make leaves. Everything else from Cake Decorating Made Easy was in Shirley's booklet.
Okay.
And that is a
Yeah,
huge red flag because that is
yeah.
a substantial portion and it's the core of the work.
Right. Okay. So now we're going from things were kind of a toss up to now things are
It's looking like this isn't fair use.
so now what about the fourth thing, the effect?
Yes. So the effect is looking at what effect did this have on the market for the original? And the answer to that is
I think it's
pretty
pretty clear.
substantial,
Yeah,
potentially, right?
it's-
Like instead of buying 15 copies of the book to keep as a classroom set, which is totally possible, you know,
Yeah.
it costs $30.
$30.
I
Yeah.
don't know, can't do the math in my head about how much that would be now.
No, I also think I think I remember reading something about she had, a couple hundred students and total, and like a good chunk of them
Mhm.
opted into this cake decorating thing. So
Yeah,
yeah, but yeah, having a 30 book or a 15, 20 book class selection
right.
set of these books could have worked in her favor.
and it would have been totally feasible. And if it was in the classroom, like then that would have been fine to have students use it because you'd already bought the book, right?
And on top of that, you've got an actual example of how this affected Eloise's book and marketing the book. You've got a parent who said, I already have this stuff. Okay. I
Why
don't
would I buy the
need to
book?
buy your book.
Yeah, right.
Right.
Yeah. And the court kind of says, like, a lot of this is hard to prove. Like, how do you prove that someone would have bought my book if
Right.
you hadn't infringed on my copyright? Like, that's
Right.
tricky.
But it still isn't looking good.
Right. It is not looking good. So while, it's difficult to kind of say precisely that, yeah, you had a negative effect on the market for the original work,
Mhm.
like this one, if it's not a toss-up, it definitely leans towards Eloise.
Right. Right. Exactly.
Yeah. So factors 1 and 2 are toss-ups. They're ties.
Yep.
3 and 4 weigh against finding for fair use. So because of that, we weigh all 4 factors together. We toss them into the garbage can. We shake them up. We see what comes out.
Mm-hmm.
And because of the way that these weigh against a finding of fair use, the court says that, yes, you, Shirley, infringed on Eloise's copyright for Cake Decorating Made Easy. And the court remanded the case back to the trial court to determine the amount of damages that Shirley owed Eloise for infringing on her copyright.
All right.
And that's where questions about, like, how much harm did this do are going to come up.
Right. So did you find out exactly how much the damages were?
No, there wasn't any subsequent decision that I could find. So that makes me think that they just probably settled this out of court. And if I were a reasonable person, I would say, like, hey, give me the profit for 15 books.
There you go, folks. Copyright in the classroom. It's not as cut and dry as one might think. You've got, like
Or
we
one
said,
might want.
or one might want, like, listen, you want to play a movie in a class, you want to, listen to music or, something like that. Generally, you're going to be okay.
That's okay. It's
Okay.
distributing copies or cutting and pasting that can
Yes.
get you into trouble.
Exactly. So be careful out there, everybody. And
Just don't use too much.
and don't use the core stuff. And
The heart.
it's the same thing when we teach our kids about writing and plagiarism and things like that. Providing credit to the source material is so important. You are taking somebody else's ideas, right? And what you don't want to do is present those ideas as your own. Similar to the case that we covered a couple of weeks ago, right? With the AI case, right? Like,
Yeah.
even though that wasn't somebody else's, a person's other ideas, it wasn't their own ideas.
Right.
And so anytime you are passing along information that did not come from you, you have to be careful about that. You have to give that thought, right? And so these 4 factors are good things to consider when you are engaging in, sharing somebody else's work and ideas.
One might say necessary things to consider.
There you go. There you go.
Yeah. And the big thing is, like, the substantiality of the amount used.
Yeah.
And the question of, like, am I giving them so much that they're not going to have to buy the book
Right.
when I probably should have just had them buy the book?
Right. And,
Right.
am I doing enough to provide the credit where credit is due?
Right.
Right?
Right. Because that can go a long way to making
Right.
it fair use. Yep.
Right. All of that
Hmm.
stuff. Those are our big takeaways. Or those, you could say, are the icing on the cake.
Hey, there it is.
No, there, yeah,
Yeah, we didn't get through the entire episode without a cake pun.
yeah, it wasn't a good one. But,
What you followed through, and I appreciate that.
All right, let's do the homework.
Yeah. So
You
to
have
put a
your
cherry
cake
on
and
top.
eat it too.
Oh, that's good.
You like that?
Yeah. Find Chalk and Gavel wherever you get your podcasts. Please like, rate, review, subscribe. That is a huge help. We would love it if you shared the show with your colleagues, with your students, with your professors, whoever it might be. Anything to get the word out about the show and to kind of share what Jamie and I are doing. We love doing the show and we're incredibly proud of it. So we would appreciate any help in spreading the word. You can go to our website, chalkandgavel.com. We've got our teaching guide up there if you're looking for some ed law content to use in your classes. It's broken down by subject, topic. It's got discussion questions. Hopefully it's a very useful resource for you all if you want to think about assigning Chalk and Gavel. And last but not least, you can go and support the show on Patreon. $2 a month helps us pay the bills and keep this show rolling.
All right, everybody. That does it for today. So we'll see you again in 2 weeks. Have a good one.